Good afternoon. So this video is going to be about blind justice. I do want to insert a mea culpa at the front of it. I answered on Furry Potatoes demur when I was analyzing the demur. One of the parts I analyzed was the court awarding costs to the school and the congregation. Now, costs may include attorney's fees. And attorney's fee, but they only include attorney's fees if those attorney's fees are allowed by statute or by case law or by contract, like if it's embedded into a contract, if prevailing party fees are embedded into a contract. Now, I was under the mistaken impression when I made the video that the Bain Act allows for prevailing party attorney fees. I was looking at it today for a client, and I noticed that the language actually allows the plaintiff to receive attorney's fees if the plaintiff prevails. So the defendant is never entitled to attorney's fees. The school and the congregation are, of course, defendants. And so that will drop significantly the amount of monies that they will receive from Furry Potato and or her attorney, probably somewhere at a minimum $435, because that's the filing fee for a response and answer. It's the first paper responding to a lawsuit. So in this case, it would have been a demur. And then there may be a few other little costs associated in, probably less than $500, definitely less than $1,000. So there you go. I was wrong, and now you have it on the record once again, and I'm sure I'll be accused of not admitting when I'm wrong multiple times in the future. Now, speaking of being wrong, Blind Justice made this comment on my Blind Justice May Elect a Trial de Novo Barkin' While Parkin' video today. And there's two possibilities. Possibility number one is that the judge, Chris Freeman, doesn't know his asshole from his elbow, and the attorney for the prosecution doesn't know his asshole from his elbow, and Blind Justice's own attorney doesn't know his asshole from his elbow, because there's no mention of the validity of RAS or probable cause. Prosecution agreed with somebody that it was a consensual encounter, but then prosecution's closing argument was officers can make mistakes and cited Hind v. North Carolina. This is supposed to be Hind, not Helen. He also argued that I lack basic respect for law enforcement. His case was cops can make mistakes and Mike doesn't respect them for it. Now, I think that Mike missed something. I'm going to call him Mike because he referred to himself as Mike, and I'm not going to call him Mr. Nelson because, well, I can. So this is Hind v. North Carolina, and in Hind v. North Carolina, Hind and a passenger, I believe, were going down the road, and a state trooper saw that a brake light was out, or thought a brake light was out. I guess it flickered or something like that as he pulled him over. Anyway, the trooper pulls him over, says, "I'm pulling you over for a taillight or for a brake light being out," and proceeds to find drugs, I think, in the car. It didn't just go to that. I mean, he talked to him, they were going to different destinations. They didn't have matching stories. Eventually he searched and he found drugs. So obviously Hind wants to suppress that evidence, and he takes it all the way up to the Supreme Court. He goes all the way up to the North Carolina Supreme Court, who says, hey, officers can make mistakes. And then he gets up to the Supreme Court of the United States, and they say officers can make mistakes. But what do they say officers can make mistakes about? Well, first of all, they're talking about probable cause. So the Fourth Amendment requires searches and seizures to be reasonable. It's tied to a reasonability standard. And the question before the court is, a mistake of fact can still be reasonable. An officer can have a reasonable mistake of fact, but can the officer still justify a stop with a reasonable mistake of law? So they look at the code section, and the code section only says it has to have a stop lamp. The stop lamp, a stop lamp. The stop lamp may be incorporated into a unit with one or more other rear lamps. So the question becomes, do you have to have more than one stop lamp, one brake light? And the North Carolina Supreme Court said, well, you only have to have one, but the officer made a reasonable mistake of fact. Now, nobody had ever taken this to court. There was never before any ruling on how many brake lamps you needed. So it was a genuine question of, is the officer's mistake reasonable, because no court had ever really looked at it before. And so the Supreme Court says that, well, first of all, they start off with, the touchstone for a Fourth Amendment seizure is whether or not it's reasonable. Because if you look here, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, right? So the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches shall not be violated. Therefore, if a search is reasonable, if a seizure is reasonable, then it's not violating the Fourth Amendment. So reasonability is a touchstone of the Fourth Amendment. And they look at it and they say, well, North Carolina has never really adjudicated on this particular statute before. And so, it's reasonable. They have little difficulty concluding the officer's error of law was reasonable. The use of other to everyday reader of English, that a stop lamp is a rear lamp and blah, blah, blah. So, it could have gone either way. So it's fine in this particular case. The officer's mistake of law was reasonable. And so he did have probable cause. And because he had probable cause, then the drugs aren't suppressed. Now, Mike goes on and on about how there was no talk about the validity of the stop. But then prosecution apparently goes out of his way to say it was a consensual encounter. It was not a consensual encounter because, in case you guys don't remember, the officer pulled them over. You could see the lights flashing. Cherries and berries, I think the cop channels like to call them. So it was not a consensual stop. They submitted to the show of authority by the police. It was a seizure. They were seized. So the only question becomes whether or not there was reasonable suspicion or probable cause for the stop. If there was reasonable suspicion or probable cause, then everything proceeds. If there was not, then everything doesn't proceed. It sounds like what the prosecution was claiming was that the officer was mistaken about whether or not they could be trespassing. That's my best guess at this point, trying to make sense out of the nonsense that Mike posted here. My best guess is that the prosecution tacitly agreed that the officer made a mistake about whether or not he could stop them for trespassing in that church parking lot. So that's going to be interesting, because I don't think that the officer is going to have a good shot at the reasonable suspicion based on, or probable cause based on, trespass in a parking lot under North Carolina law. Because I assure you that trespass in North Carolina has been litigated, highly litigated. It is not something that is questionable, like whether or not you have to have two operable lamps, or whether or not one of your brake lamps can go out and you can still be in compliance with the North Carolina statutes. So that will be something interesting to see. It will still be the judge, I believe, determining whether or not there was probable cause. Because normally a suppression hearing is with the judge. I don't know entirely about North Carolina. Maybe they do it. Maybe they do that in front of a jury. But my best guess would be that a suppression hearing would be in front of the judge, because if they could suppress all the subsequent evidence found after the stop based on the stop, then there you go. So that will still be up to the judge, but it will be a different judge, and then you'll go from there. So anyway, that's my take on what Mike reported to me. It would be lovely to see any. I mean, Mike, if you want to give me the documents, I will review them fairly. I mean, I think you should know me by this point. I'm really just interested in justice. And, if you were right, then you were right. And if you weren't, then you weren't. And if I was wrong, I'll be happy to admit it. So, I mean, if you want to send me the documents, feel free. I'd be happy to take a look at them. Thanks for watching. Have a great day.